Hi, this is David for 10 on Tactics for tacticsandtrials.com. Please remember to subscribe to the channel and to hit the like button. If you have any questions or comments, please feel free to leave them below. Today's case that we will cover is Napouk v. Las Vegas Metropolitan Police Department 123 F.4 the 906 2024 from the Ninth Circuit Court of Appeals. The case addresses the fatal shooting of Lloyd Gerald Napouk by officers of the Las Vegas Metropolitan Police Department, LVMPD, and examines the application of qualified immunity in the context of alleged excessive force under the Fourth Amendment, deprivation of familial relations under the 14th Amendment, municipal liability under Monell v. Department of Social Services, and state law claims. On October 27, 2018, LVMPD officers responded to multiple reports of a man, later identified as Lloyd Napouk, behaving suspiciously in a residential neighborhood. Witnesses described him as carrying a machete, Slim Jim or long stick, and acting erratically by peering into cars and homes. Upon arrival, Sergeant Buford Kenton and Officer Cameron Gunn encountered Napouk, who was holding an object resembling a long, bladed weapon. Despite repeated commands to drop the object and stop advancing, Napouk ignored the officers and continued to approach them. When he came within 9 feet of Sergeant Kenton, both officers discharged their firearms, resulting in Napouk's death. The object was later identified as a plastic toy fashioned to look like a blade. Here is a detailed timeline of the encounter. 12:17 a.m., a resident reported to LVMPD that a man was walking along Floating Flower Avenue, peering into vehicles, walking onto patios, and carrying what appeared to be a black sword or stick. 12:20 a.m., another caller described the individual as an African-American male wielding a machete, big tool, or piece of metal, going door to door, talking to himself, and pointing the object at houses. 12:25 a.m., the first caller contacted LVMPD again, stating the man had moved to Tender Tulip Avenue, was entering backyards, and looking into windows. The caller expressed concern for safety, indicating he was armed and would defend himself if necessary. 12:31 a.m., Sergeant Buford Kenton and Officer Cameron Gunn arrived in the neighborhood, receiving information from dispatch about a male wearing a baseball cap and camo backpack, carrying a Slim Jim, long stick, or possibly a machete, and peering into windows. 12:33 a.m., Officer Gunn briefly spoke with a bystander who indicated that the suspect was one street over and wearing sunglasses. 12:34 a.m., both officers proceeded to the next street, where they observed Napouk emerging from between two houses, holding an object they believed to be a machete. Officer Gunn activated his patrol car lights and parked in front of Napouk, while Sergeant Kenton parked behind. 12 hours, 34 minutes, and 5 seconds. A.M. Officer Gunn exited his vehicle with his firearm drawn, instructing Napouk to put it on the ground and to drop the object. 12 hours, 34 minutes, and 45 seconds a.m. Officer Gunn requested a code red over the radio indicating an emergency and informed dispatch that the subject was not following commands and had stated they would have to shoot him. 12 hours, 39 minutes, and 2 seconds a.m. After approximately 5 minutes of attempting to communicate and de-escalate the situation, Napouk advanced towards Sergeant Kenton, coming within 9 feet. Both officers discharged their firearms. Officer Gunn fired 3 rounds and Sergeant Kenton fired 4 rounds, striking Napouk multiple times. 12:54 a.m., Napouk was pronounced dead at University Medical Center. It was later determined that the object Napouk was holding was a 22-inch homemade plastic machete. In addition, throughout the encounter, Napouk did not comply with officers' commands to drop the object and to stop advancing. He appeared to mumble phrases like "get out of here," but did not engage in clear communication. Both officers utilized their body-worn cameras, which captured the incident. They attempted to maintain distance and used their patrol vehicles for cover while issuing commands. A subsequent investigation by the Clark County District Attorney's Office concluded that the officer's use of deadly force was not criminal, citing the perceived immediate threat posed by Napouk's actions and the object he wielded. Napouk's parents and estate filed a lawsuit against the officers and LVMPD, alleging excessive force in violation of the Fourth Amendment deprivation of familial relations under the 14th Amendment. Municipal liability under Monell v. Department of Social Services, 436 U.S. 658, 1978 state law claims under Nevada law. The United States District Court for the District of Nevada granted summary judgment in favor of the defendants. The plaintiffs appealed to the Ninth Circuit Court of Appeals. Judge Lawrence Van Dyke, writing for the majority, affirmed the District Court's summary judgment, addressing each claim as follows. The Fourth Amendment, excessive force claim. The court applied the standard from Graham v. Connor, 490 U.S. 386, 1989, which assesses the reasonableness of force based on the totality of circumstances. The court found immediate threat. Napouk posed an immediate threat by advancing towards the officers with what appeared to be a weapon. Refusal to comply. He ignored multiple commands to drop the object and stop moving. Proximity. He closed the distance to within 9 feet of Sergeant Kenton. Given these factors, the court concluded that the use of deadly force was reasonable. Even if it were not, the officers would be entitled to qualified immunity, as their actions did not violate clearly established law. 14th Amendment, deprivation of familial relations. The plaintiffs alleged a violation of their substantive due process rights. The court held that there was no evidence the officers acted with a purpose to harm unrelated to legitimate law enforcement objectives. Therefore, the claim failed. Municipal liability Monell claim. Under Monell, a municipality can be liable if a constitutional violation results from an official policy or custom. Since the court found no constitutional violation by the officers, the Monell claim against LVMPD failed. State law claims. The court determined that the officers were entitled to discretionary function immunity under Nevada law, shielding them from liability for the state law claims. Judge Ryan Nelson concurred with the majority and emphasized that substantive due process does not extend to the relationship between parents and their adult children, reinforcing the dismissal of the 14th Amendment claim. Judge Gabriel Sanchez dissented, arguing that the majority failed to view the evidence in the light most favorable to the non-moving party, as required at the summary judgment stage. The judge contended that a reasonable jury could find that Napouk did not pose an imminent threat. He was not committing a crime or actively resisting arrest. Non-lethal alternatives were available and not utilized. Therefore, the case should have proceeded to trial. In the end, the Ninth Circuit affirmed the district court's summary judgment in favor of the defendants, holding that the officers' use of deadly force was reasonable under the circumstances and that they were entitled to qualified immunity. The court also dismissed the plaintiffs' 14th Amendment, Monell, and state law claims. The plaintiffs filed a petition for rehearing en banc, which was denied on March 26, 2025. Judge Sanchez voted to grant the petition, but no other judge requested a vote, leaving the panel's decision as the final ruling. This is David for TacticsandTrials.com. I look forward to seeing you again for the next legal update.